Welcome to Legal Riffs with the law offices of Jason L. Wilson. I recently did a video where I talked about the importance of helping your doctors to put objective medical evidence in your medical records to improve your chances of winning your Social Security disability claim. Today, I'd like to talk about one more thing that you can do to improve your chances of getting your disability application approved. Now, if you're filing for Social Security disability, you need to know that it is not easy to get a disability application approved by Social Security. Social Security denies the majority of initial applications, and most of those cases end up going to a disability hearing before a Social Security judge. The Social Security judges have to apply the Social Security rules and regulations, and those regulations put the burden on you to prove to Social Security that you're unable to work. How do you do that? Well, mainly with objective medical evidence in your medical records. But you normally also have to testify at a hearing before a Social Security judge. For example, let's say you have chronic back pain. So you go to a hearing and you tell the Social Security judge that the back pain is excruciating and it radiates down your leg. You may say that because of that pain, you can only stand or walk for no more than 15 minutes at a time. Or you may say that you can only sit for 15 minutes before you have to get up and move around to try to get some relief from the back pain. The Social Security judge will review your medical records very carefully to see if what you told the judge is the same as what you reported to your doctors at your medical visits. They are checking to see if what you say at your disability hearing is consistent with what you have said to your doctors. If you tell the judge that you can only stand or walk or sit for 15 minutes, but you don't tell your doctors that, then the judge is going to use that as a reason to deny your disability claim. So, what can you do about this? Two things. First, if your back pain is so bad that you can only stand or walk or sit for 15 minutes, or if your anxiety is so bad that you can rarely leave your house and go out into public, or if your carpal tunnel syndrome is so bad that you constantly drop things like coffee cups, or however your medical problems limit you, you must make sure that you tell your doctors about it at your appointments with them. And second, and this is just as important as the first, you must ask your doctors to put what you tell them in their treatment notes. They don't always do that, and you need to ask them to do it. If both of these things happen, then the Social Security judge will see that what you say at your disability hearing is consistent with what you have reported to your doctors. And to make certain that this happens, you need to tell your doctors about your symptoms and your limitations at every appointment, every medical appointment that you have with your doctors. And you need to ensure that the doctors know that a Social Security judge is going to be looking at their records later, and they're going to be looking for this information. Doing this will help you to meet your burden of proving to Social Security that you are disabled from working.